Good evening and a very warm welcome to all the attendees joining us for today's Vidhi Talk session, which is an initiative of the Bar Council of the Punjab and Haryana at Chandigarh. Vidhi Talks, ladies and gentlemen, is a platform dedicated to enabling thoughtful, practical, and high level discussions on contemporary legal challenges and the emerging trends. This evening, we are gathered to explore the nuanced strategic interventions that these stalwarts and legal practitioners employ under Section 9 of the Arbitration and Conciliation Act. Today's topic of discussion, ladies and gentlemen, is litigate to arbitrate strategic interventions under the Section 9 of the Arbitration Act. Whether it is to secure assets, prevent further contractual breaches, or invoke or not invoke the bank guarantees, or set stage for an impending arbitration, Section 9 has proven to be a very powerful and sometimes contentious legal remedy. This session today remarks upon what we will address through our panelists, both the pre-arbitral and post-arbitral usage of this provision, alongside drafting considerations, jurisprudential shifts, and the tactical strategies. We are honored to be joined by an eminent panel of legal experts who are shaping and refining the practice of arbitration across India and beyond. Ladies and gentlemen, it gives me immense pleasure to introduce to you our first panelist, Mr. Sarthak Magan. Advocate Sarthak Magan is the founder of Sarthak Magan Law Offices and is a graduate of the Symbiosis Law School, Pune, with a BBA LLB degree and also holds a BA in Political Science from the University of Delhi. Interestingly, he began his career with the capital markets team at the Shardul Amarchand Mangaldas before establishing his independent litigation practice in Delhi. He works extensively across forums in Delhi and Mumbai with a focus on civil, commercial, criminal, and real estate and construction law. He also leads a foundation that provides professional legal aid to early stage social responsibility startups. Recognized by the business world in its 30 under 30 and by the Forbes as one of the top 10 individual lawyers, we would be blessed to welcome this young and dynamic lawyer, Mr. Magan. We welcome you here to this panel, sir.
Thank you, Maya. Thank you for having me.
Ladies and gentlemen, the second panelist we have here today is Mr. Ish Jain, who is an international arbitration practitioner and leads the arbitration, technology, and aerospace practice as a senior partner in a law firm that is Regis Legal LLP. He has also been practicing as an arbitrator, ladies and gentlemen, since last 9 years and is presently empaneled as an arbitrator with the Chandigarh bench of the Punjab and Haryana, that is the notification which you have seen for the impaneled lawyers, the arbitration practitioners who keep filing Section 11 petitions. You often will find the name of Mr. Ish Jain in that. He is also impaneled as the arbitrator in more than 24 arbitration institutes in the United Kingdom of Great Britain, the Middle East, the South Asia, Russia, British Virgin Islands, and Mauritius, as well as 4 other high courts in India, ladies and gentlemen. We wish you a very warm welcome, sir.
Thank you, Maher. Pleasure to
Thank you
be
so
here.
much. Thank you for being here. Ladies and gentlemen, let me introduce you to our third panelist, Madam Jayashree Parihar. She is a commercial dispute resolution lawyer based in New Delhi, currently practicing with the disputes team at PSL Advocates and Solicitors. Prior to PSL, she was a part of the commercial disputes team at the leading law firm Trilegal Delhi. Her practice primarily focuses on arbitration with a particular interest in international commercial arbitration involving multinational corporations, involving thousands of crores and multi millions of dollars, ladies and gentlemen. She has represented Indian and international clients before the arbitral tribunals and judicial reforms and has worked extensively on matters involving third party funding and constitutional bench matters regarding the nuances of the Arbitration Act as well. She is also an expert in the comparison laid out with regard to the different statutes of different countries on the arbitration laws. Interestingly, she is also an author contributing to LexisNexis on alternate dispute resolution and has co-authored the India chapter in the Delos Guide to Arbitration Places. Her publications span across arbitration, insolvency, and insurance, including a chapter on emergency arbitration in the Walters Cludwer title. I'm sorry for my pronunciation, but interestingly, ladies and gentlemen, this is the subject matter here today. Emergency arbitrations is definitely what is being covered under Section 9. Jayashree has been recognized by the Forbes India Legal Power List 2022 Arbitration and Mediation and named a recommended lawyer by the Legal 500 in 2022 and again in the year 2023. A strong advocate for gender diversity and arbitration, she is a part of the ERA Pledge India chapter and has held leadership roles in the Young International Arbitration and Mediation Center, Hyderabad. She also serves as the member of the organizing committee of the Delhi Arbitration Weekend and regularly is a keynote speaker at national and international conferences. We wish you a warm welcome, ma'am. Thank you, thank you. I think there is some voice issue. Could you please?
Is it better now?
Yes, yes, yes. We wish you a warm welcome.
Thank you so much for having me. Thank you.
Thank you. And to set this context now, ladies and gentlemen, I would start this panel, as you all know the custom, by inviting each one of our panelists to share the brief opening remarks on the strategic value and the judicial evolution of the Section 9 of the Arbitration and Conciliation Act. So, to start this session, I will be asking first Mr. Sarthak Magan to share his opening remarks in 3 to 4 minutes, please. Over to you, sir.
So, Mahir, I know Section 9 and especially Section 9.2 leaves many of questions unanswered insofar as the unwanted consequences sometimes of interim orders are concerned. How the courts, however, have now, especially in the Delhi High Court, taken a hands-off approach by not having a parallel adjudication. But the consequences still remain. There will be judicial intervention. There will be major inconvenience to any party which is granted an interim order, especially when it gets extended beyond the scope of its requirement or beyond the 90-day period. Interim orders, and I know you will, this is a question that Ish at some point will have to answer. Interim orders gain the status of de facto permanency of some sort when they get continued as Section 17 orders, even if the courts were to take a hands-off approach and have an observation. This also, in some respect, allows courts which are not dealing with a larger dispute to give a party an upper hand in terms of an ex parte interim order, and especially an ill-obtained injunction order, which then continues itself beyond the merit. So I think there is a requirement to reconsider insofar as the initial requirement of initiating the arbitration proceedings in a time-bound manner is concerned after the obtaining of these interim orders. I think for the opening remarks, I'll leave it there. You're on mute, Myers.
That's a very interesting remark. Ladies and gentlemen, you may note that Mr. Magan has said that the judicial interventions are there, but with regard to the scope of the ex parte interim orders, the continuation goes beyond the merit. That is a very interesting remark. Thank you so much for those remarks, sir. Let's move on to our next panelist, Mr. Ish Jain. Your opening remarks, please.
Thank you, and good evening, everyone, and thank you for having me here today. And it's a privilege to speak on an issue that sits at the top of national justice system and the international arbitration regime, and the role that India plays and the Indian courts play in terms of Section 9 of the Arbitration Act in India, especially in relation to when it comes to cross-border disputes or the growing culture of having emergency arbitration awards, emergency arbitration orders. Now, in terms of how Section 9 has evolved, it's a very long journey that began with the 1940 Act. And if you saw the provisions of the 1940 Act, interim measures that were available to the courts to grant were far, far larger, and we did not have a lot of scope for the arbitrators to decide and discuss on the issues which could have been led, to argue before the arbitrators. And as time has progressed with the 1996 Act, it was assumed that that would change. But it took, I think, until 2001, 2002 for that entire perspective to change, where the courts started appreciating that there is some semblance of autonomy which is to be given to the parties to approach the arbitrators under Section 17. And the entire change in, or the shift in the regime took place in the year 2015, when the amendment uh, took place to the Arbitration Act, where the powers of Section 17 were widened enough to equate to almost all the powers that are available with the courts. And that's the kind of power that we now have under Section 17 and Section 9. So really, it's going to be a very difficult task to find a balance between that Section 9 and Section 17, when both have almost equivalent powers. And at what point of time does the court stops interfering and relegate the parties to approach the arbitrator under Section 17 is going to be a very crucial element in the coming years. And that's something that is yet to be explored, because it's still left to the discretion of the judges of how this has to be done. We have judges in certain courts who have been very pro arbitration, who have relegated parties to go to Section 17, where there was no emergency or any overnight urgency which required them to deal with that matter under Section 9. And we have had judges and certain courts where the parties have approached under Section 9, and the courts have kept it lingering for months and months, and probably sometimes years, before they are even relegated to arbitration, so which defeats the entire purpose of arbitration. So these are the things that we will hopefully be able to look into and recognize. I don't know whether we can address that sitting on this side of the bench, but I'm sure we can recognize them and find a way to appeal to the courts, appeal to the judges to appreciate different perspectives, depending on which party we are representing, obviously. But let's hope to a better learning today.
Absolutely. We are looking forward to hear more about your insights on this subject, especially when you made the remarks that Section 9 versus Section 17, the powers both have been widened enough, and we need to draw some lines, and some judicial interpretations may be able to help us. Let's hear more from you during the Q&A session. Let's move on to Madam Jayashree Parihar. Jayashree, please uh, give your opening remarks on the subject matter.
Thank you. Thank you, Mahir. I believe a lot of important points have already been covered by my co-panelists. But as an overview, I would like to say that from a practitioner's perspective, Section 9 is the most handy remedy that we have, be it from the claimant's perspective or the defendant's perspective. Because in both scenarios, I can go ahead and advise my client how Section 9 is so useful. Go ahead and get an interim measure and some sort of an interim protection which I can get. So, according to us, practically, this has become a very important remedy, which on very frequent basis we go and approach courts to for before the constitution of the tribunal, especially before the constitution. Now, I would like to just touch upon how outside of India, the entire global sentiment is towards arbitral institutions and institutional arbitration. So Section 9 in that sense, and the issues which we have with Section 9 as it stands in our Act presently are very India specific. Because outside ad hoc arbitrations are very, on the contrary, in India, institutional arbitrations are far lesser than ad hoc arbitrations. Section 9 and its discourse on the issues that we are facing are also very peculiar to our specific jurisdiction, which is India. So from that perspective also, I think it's a very crucial remedy for us to examine. And I'm glad that you have gone ahead and hosted this panel discussion which talks about such an important remedy, especially to get an interim protection of sorts before the arbitral tribunal is constituted or after, and also from the perspective of emergency arbitration, like Thomas Again. So without taking more time in my opening remarks, I'll just leave my opening remarks here and then answer it in my question and answer.
Thank you. Thank you so much. And on that note, please hold that thought on ad hoc arbitrations. Our viewers would like to know more about it, what it is, what are the common practices in India and abroad, especially the hotly contested places for arbitration, such as Singapore and London, I would say. So we will get back to you on this. So, ladies and gentlemen, as we move now, with the opening remarks being done, we would now move to the core of our session. I will be directing a series of carefully crafted questions in a rotating format to ensure that each speaker can build a discussion while contributing their individual perspectives. So, in this first round, I would like to start with Mr. Sarthak Magan, and I have a question for you, sir. So, this question has, first of all, has come from the young lawyers, ladies and gentlemen. All these questions have been handcrafted by them, and these curious souls would like your esteemed answers. So, first question is, what are the most common practical triggers that push the litigants to seek interim relief under Section 9 even before initiating the arbitration proceedings? Over to you, sir.
Thank you for that question, Mahir. Like Jayashree said, Section 9 is not only one of the greatest weapons in your armor, it's also the chink in your armor, depending on what side you're at. But litigants do frequently turn to Section 9 when there is an immediacy or a severity of a harm that they anticipate, and if there is no urgent intervention occurred, that harm could become irreparable, and that is also one of the aspects that you have to prove to a court for getting a remedy under Section 9. Now, the practical triggers would first of all be preservation of the subject matter of the dispute itself. For example, in construction or real estate disputes, it will be developers or landowners seeking injunctions to prevent third-party sales or possession. There could be a risk of the dissipation of assets to render an eventual arbitral award and to defeat its purpose. That predominantly happens in financial. Can you hear me? I'm sorry.
Absolutely, we can hear you.
Would
Financial.
have which would be in financial or say shareholder disputes where there could be a disposal of movable or removable assets at the behest of parties or non-parties alike. So there are asset freezing orders that are required, especially when there is a demonstrable risk, and it has to be demonstrable, of course, of asset flight. Um, then there is also commercial deadlines, which can cause irreparable injuries. This predominantly happens in say exclusive supply contracts, IPO listings, any time-bound regulatory permissions that may be required. Um, Now, the most important, and this is something that is also required to be proven as a manifest intention to arbitrate, is the non-availability of the arbitral tribunal. And a lot of courts in Section 9 arbitrations do eventually appoint the arbitral tribunal and relegate parties back to the tribunal with an effective remedy under Section 17. So where the arbitration has not commenced, where there is no cooperation from the other side, where the parties, for example, cannot come up to a solution in respect of who the principal arbitrator is going to, the presiding arbitrator is going to be, then Section 9 becomes an avenue to not only achieve that, but maybe also an interim order, which is highly unlikely if you've not taken any steps, or if you were to show or demonstrate to a court that there is a non-cooperation inter se amongst the parties, the court more often than not will appoint the arbitral tribunal for you. Next, and I enjoy this the most, is the preservation of evidence, of preventing any breach of confidentiality, largely in intellectual property, trade secret disputes, and leakage of any sensitive information, and more importantly, for forensic preservation of digital records, and that is key to a wide array of arbitrations. And finally, maintaining status quo of any nature to restrain parties from altering a situation as it exists. So these would be some of the larger practical triggers which get parties to file Section 9 petitions to start with before the courts.
Well, thank you for that answer, which takes me to add on. Mr. Magan, there is one more factor which is very common, especially in the commercial loan disputes, lot of immovable vehicles, which is generally not for seasoned practitioners. They're not handling such disputes. but it is a part of the culture, and being a part of the statute, that is also one of the important things that keeps happening. That lot
Absolutely.
of these loan companies, they are taking these one-sided arbitration agreements, which the a loan applicant doesn't even know is an arbitration agreement, and they get the Section 9 petitions filed and done. So that is that. Second of all, we would like to know one of your perspective on the preservation of digital evidence. So, Mr. Magan, could you please tell us, suppose somebody has to mandatorily get something videographed, saying that this is very important and it is emergent in nature. So, under the Section 9, can even videography be done?
Local commissioners are appointed through courts, and yes, that process is very much possible.
So that that result of that videography, whatever video comes out or digital evidence, does that turn out to be an absolutely admissible evidence in the eyes of law? Our viewers would like to know.
That would very much depend upon the arbitral tribunal.
Thank you, thank you, thank you for that answer. All right, so let's move on to our second panelist. We'll ask now Mr.
I
Ish
think
Jain.
Jayashree wanted to add to that
Yeah.
question.
I just
Oh
wanted
yes,
to
please.
what Sarthak had mentioned, because we've done a couple of matters like this where a local commissioner is appointed, and their reports are submitted along with video evidence, which is then taken into consideration by the arbitral tribunal and then taken into evidence subsequently. In such cases, from both sides, what we have done is, A, of course, present it as evidence and prove it, because local commissioner is an independent person who's going ahead and doing this survey. But from the other side, we've also gone ahead and, in terms of CPC, called the local commissioner if something is fishy in the report or we do not agree to it. And we've called them to go ahead and withstand the cross examination which we do of them. So if you want to challenge the report on any fact, that's something that we have done. So these two options are available for us to go ahead and prove any video evidence which is there, or in fact challenge, like
Thank
Sarthak.
you.
Absolutely, and more importantly, since this is a court-appointed local commissioner through a Section 9 application, it has that much more value in evidence before the arbitral tribunal as well.
Yes. Thank you so much for adding that, Jashri. Now let's move on to Mr. Ish Jain, and let's hear his answer on this particular question from the cross-border arbitration perspective. Sir, how do the Indian courts interpretations of Section 9 compare with the interim measures granted under the international rules, institutional rules like ICC or SIAC?
Well, thank you, Maher, for that question. To start with, from I'll repeat what I said. Even from the cross-border perspective, Indian court's interpretation of Section 9 has undergone a significant transformation, and particularly post 2015 amendment, where once the courts were hesitant to extend interim measures to foreign-seated arbitrations, they now do with great confidence. Obviously, provided that the parties have not expressly excluded the Indian court's jurisdiction. But having said that, today the Indian courts are routinely granting interim measures, asset freezing orders, directions to furnish securities, even in support of arbitration cases, which are seated outside India, as you've seen in the Rafael's Designs case, which was, I think, in 2016. This change reflects an encouraging shift towards aligning Indian arbitration regime with the international uh, arbitration regimes or commercial expectations that are there from people investing in India or people transacting with Indian parties. However, if we compare this with the institutional rules like those we have in SIAC and ICC, we can see that these institutions offer more expedited relief through emergency arbitrators, uh, and the provisions for those are set in the rules which are in SIAC or ICC rules. This enables parties to obtain interim measures in matter of days. While such emergency arbitration orders were initially viewed as falling into the legal gray area in Indian law, but obviously with the Amazon the Future Retail case that settled the debate, and the courts recognized the enforceability of arbitration awards, uh, and thereby lending judicial weight to institutional interim measures granted by foreign institutions like ICC and SIEC. Now, that said, it's important to acknowledge the practical distinction between both of them. The relief which is under Section 9 is normally backed by the court's authority and is often slower and involves procedural formalities. There are a lot of things that we need to do as lawyers when we uh, file our cases for Section 9 reliefs in the courts. And on the other hand, institutional measures are often speedy, flexible, commercially more responsive, and particularly valuable when parties have expressly excluded Indian court jurisdiction, or where parties have not been able to finalize which country will have jurisdiction, or in cases where time is of absolute essence. That's something where the Section 9 reliefs do fall short. So there are practical distinction in terms of the powers. There is no much real distinction between the powers,
Right.
uh, but it's more of a practical distinction. What kind of relief do you need? And depending on that, you would pick whether you want to go under Section 9 or whether you would want to go under emergency arbitrations. As I mentioned, this. So when we say that institutional emergency arbitrations are there, they are identical to Section 17 powers, right? So it's as good as comparing the Indian Section 17 with the Indian Section 9. You would decide and take the call depending on what is practically more suitable. If there is an overnight urgency, you would rather prefer to go before the arbitrator because you could arrange a meeting overnight. uh,
Yes.
if you had little more space, and if you wanted something with much more authority, you would have gone under Section 9. It's identical in the SIC or the ICC rules, where they are emergency arbitration provisions and rules are identical to our Section 17 rules and the criterias. So it's more of a practical distinction, I feel.
Correct. Well, thank you. Thank you for that answer. So let's move on to our third panelist. Ladies and gentlemen, let's ask Madam Jayashree Parihar, when advising clients, how do you determine the right time to invoke the Section 9, especially in cases where the arbitration clause may be loosely worded or even disputed?
Right. Thank you. Thanks for the question, Mahir. Uh, I will start answering this question by first answering the second half of it, when an arbitration clause is loosely worded. Now, when an arbitration clause is loosely worded, all I need to ensure that if the intent to arbitrate is there, and that's all I need to show. If I have an agreement, even if it's loosely worded, but goes ahead and communicates the intent to arbitrate clearly of the parties, then I'm good to go for my remedy of Section 9, which is available to me under the Act. So that's the first hurdle that I cross. That there is an
Correct.
agreement between party by showing intent to arbitrate. And then, of course, like go ahead and say that this is an arbitration agreement in terms of Section 7 of the Act. Then subsequently, if I need what is the right time and how do I advise my client what is exactly the right time? Um, any time is right time till the time there is urgency. There is a prima facie case in my favor. Balance of convenience lie in my favor. And of course, there is some sort of irreparable harm which is hanging on my head. As soon as I go ahead and satisfy these three essential ingredients, that time is the right time for me to approach Section 9 for any remedy or relief which I seek from the and in fact, Sarthak had also gone ahead and propounded on various kinds of remedies and reliefs that I can go ahead and get under Section 9 of the Act.
Correct.
Going to be repeating those, but as soon as any of these, all of these principles are met and I've established these ingredients, that's the time I will tell my client that, okay, fine, let's go to the court, get a Section 9 relief. Now, if I have to further break this question down, there are three occasions where I can go ahead and file for a Section 9. One is before the constitution of the arbitral tribunal. Second is during the arbitration proceeding, and third is post award stage. Now, my answer will slightly get modified in all of these three stages. Before arbitral tribunal is constituted, in fact, that's the time where Section 9 is used most widely, because there is absolutely no other place where I can go ahead to get a remedy or relief of interim in nature, right? So I will go to Section 9 and get my relief from court. Now, it's also the easiest because I don't have to show if an arbitral tribunal is less efficacious or more efficacious. I just have to show that there is a prima facie case in my favor, balance of convenience, and of course, irreparable harm will be caused to me if Section 9 court doesn't give me the relief that I'm seeking. Second is that if it's during the arbitration process. Now, this becomes a little tricky because then I have to additionally show to the court, apart from all of these three ingredients being met, I have to show to the court that how Section 17 remedy of a tribunal is not efficacious. Why is it so urgent that you're going to the court despite the arbitral tribunal getting constituted and already in place? So these situations would be such that if the tribunal is not functioning properly, let's say if the arbitrator is extremely unwell or is unavailable due to some reason, and there is no form or way that I can actually get an interim protection from Section 17 arbitral tribunal, then I'll go to Section 9 court and seek the same relief. Now, third occasion is also something which is quite, it's second to before arbitral tribunal gets constituted, and it's fairly used when you get an award in your favor. So once you have an award in your favor, then also you can go ahead and for protection of that awarded amount, go to the court and seek some sort of interim protection. It's very rarely granted because you already have an award in your favor. But what you have to show to the court in that scenario is that there is an active act on behalf of the person who has to go ahead and satisfy the award, which is the judgment debtor, and they're
Yes.
distributing assets intentionally to go ahead to not comply with the award which is granted by the arbitral tribunal. So in such scenarios, of course, Section 9 court can go ahead and give orders of attachment before the enforcement of the award has taken place. So
Could you give an example of this for the benefit of viewers?
Yes, of course. So, for example, if I have an award in my favor, and then of course there is a judgment debtor against whom the award is made. In that scenario, if the judgment debtor is now going ahead and transferring all the funds from the company, and that being a company, transferring all the funds from the company and making this just a shell company of sorts. In that scenario, I will definitely advise my client to go ahead and file a Section 9 because there is going to be only a paper award in my favor later on. Because if there are no assets in the company, if the transfer of assets is happening, by the time I actually enforce my award in terms of Section 36 of the Act, there would be nothing left in the company. And as all of us know, companies are a different legal entity, and attachment of private individuals and their assets is a very exceptional mode which is taken. So in such scenarios, it's a clear case where I can actually go to Section 9 court and get an interim protection even after the award is made in my favor.
Thank you for that relevant answer. I'm sure our viewers have learned a lot about Section 9. Initially, any young lawyer would think Section 9 is pre-arbitration. But there are various phases which I'm sure many viewers will learn from this expert talk. So, though you will deny to be an expert, that is the humility part. But let's now move on to the next round, ladies and gentlemen. We'll now ask Mr. Sarthak Magan one important question. That is, with the high courts or the district courts and commercial courts all exercising jurisdictions under Section 9 of the Arbitration Act, how can the litigants avoid or defend against accusations of the forum shopping?
I don't think you can avoid it when it's more often than not deliberate. I don't think there is a forum shopping is a by chance situation. Sometimes you don't have an option but to shop for forum. But regardless of that fact, with roster changes, with benches changing, when you know the view of a bench in respect of Section 9 petitions, more often than not, with justifications, especially with valid justifications, you can go ahead and shop for forum, especially when you can justify it basis a few grounds. Now, first of all, what is forum shopping? Could it be just within courts within the same state? Could it be across states? It could be both. It could be away from the seat. It could be within the seat. But the closer you remain to the seat with stricter adherence to the jurisdictional tests, the larger your chances of a successful Section 9 petition may be. Of course, merits aside, the maintainability is what is struck at first. And this becomes a more of a maintainability question. Especially when you have multiple forums exercising concurrent jurisdictions in Section 9. Section 21E, how it is defined under the Act is of course key. It very clearly defines it as the principal civil court having jurisdiction over the subject matter, and similarly for commercial courts as well. Now, second, and Bharat Aluminium versus Kesar very clearly defines it. You have to respect the seat of the arbitration. As long as you affirm that the seat remains the exclusive jurisdiction of the court, unless parties have decided to contractually subsequently modify it in a rarer situation. You also have to align it with the uh, uh, with the contractual dispute resolution clause. When you file an application before a court with an arbitration clause, if the seat and venue is defined, it gives a more it gives a, it gives a clarity in the appropriate jurisdiction. So you have to decide it from the drafting stage of the contract up until when you actually exercise it under Section 9s or under the various sections of the Act. Now, uh, and this is something that we've not seen, and I'll deal with it in greater detail when we talk about drafting. We do not provide the transparency or rationale behind why we are choosing to approach a particular jurisdiction in our pleadings. That is largely because we want to avoid that conversation. But sometimes avoiding that conversation stretches out the proceedings to such an extent, and this is more important at a pre-arbitral stage, because you don't want to stretch out your relief. Once you stretch out your relief, more often than not, you will get an arbitral tribunal which will then decide it as a Section 17 instead of the court giving you the remedy that you deserve. So you clearly justify it, whether it is because of the location of the assets, whether it is because of the performance of the contract, or whether it is because of a particular cause of action arising in that jurisdictional limit that you're approaching that court. And most importantly, and this is what also very often happens, if uh, avoid splitting proceedings. If you have an arbitral tribunal or an interim relief that has been pursued elsewhere, then approaching a different court under Section 9 without you giving any compelling justification would inevitably invite forums of shopping allegations, which you will have to deal with. And sometimes, despite the merit of your petition, it can completely throw it in the dustbin. So we have to be very careful with how we deal with this. So ultimately, while litigants do have legitimate choices, courts have now started in a pro arbitration a scenario started to scrutinize these filings very closely to discourage any sort of tactical filings which are aimed more at the bench or a procedural advantage than the merit of the dispute.
Well, I'm going to be very candid about this to my viewers. Mr. Magan has very smartly answered this question.
Were you looking for more clarity?
I'm happy to provide tough conversation, which is generally not discussed, but it's a very important discussion. So sometimes tough discussions need to be had for the benefit of the young lawyers so that they can understand the nuances of the practical side of the law, not only the bookish part.
Absolutely, it is an aspect you cannot miss. It is the first preliminary objection that your opposing side, once it appears and is issued notice on, will take, is that you're forum shopping. So this is not something that you can run away from. It's better to prepare the justification in advance and documentarily support it in your petition preemptively than have the court make a maintainability issue out of it and discuss it at length on subsequent hearings, hence delaying your relief or maybe even completely losing your relief.
Yes.
Is how I feel. There are people who there are of course practitioners who would just suggest otherwise and say don't deal with it, let it come if it comes. So I'll be very candid and say don't wait for it to come. It will come if you are going away from the seat.
Of course, and every lawyer has his own style of working. Some hunt for the food, some hunt for the pleasure. So, ladies and gentlemen, let's move on to the next question.
It's always best to take it head on.
Yes. So now let's move on to Mr. Jain. Mr. Jain, I would like to ask you, how do you see the interaction between institutional emergency arbitration and the Indian court's jurisdiction under Section 9? Can there be a conflict or a harmonious reading?
Well, thanks, Maher, again for the question. At first glance, one might assume that there is a potential for overlap or even a conflict. but in reality the relationship is evolved into a much larger harmonious one, and that's all thanks to the 2015 amendment and the recent judicial pronouncements in Amazon retail, where and other cases where parties have now approached Indian courts for interim reliefs in support of their foreign seated arbitrations, and unless there is obviously a kind of contractual exclusion, and simultaneously arbitration institutions like SIAC and ICC, who are providing their own emergency arbitrations, often are available even before the constitution of the full tribunal. So the emergency arbitrators are appointed well before the constitution of the tribunal itself. There are, and those are normally kept different from the tribunal. So
Yes.
in many of the cases the emergency arbitrator does not, even if the agreement provided for a tribunal of 3 members, it does not necessarily mean that the emergency arbitrator has to be a 3 member tribunal. It will be one member who will be the emergency arbitrator, and he may not even continue on the final tribunal. So those kind of distinctions, SIC and ICC and other arbitration institutions have started incorporating in their rules. And initially, there was a concern, obviously, over whether emergency arbitrator awards could be enforced in India. But
Yes.
and that uncertainty was obviously addressed head on by the Supreme Court, and it affirmed that emergency arbitration awards are enforceable in the Indian arbitration regime. And this not only acknowledged the efficiency of the institutional mechanism of foreign jurisdictions, but also the institutional mechanisms that are available in India, because there is a lot of skepticism in India whether Indian arbitration institutions, whether the courts will recognize emergency arbitrators appointed by the Indian institutions, whether the arbitrators appointed by the Indian institutions would be recognized. But all these were party driven objectives which were skeptical, and the courts have put that to rest and have recognized that this is okay. It's okay to have emergency arbitrations. It's okay to have institutional arbitrations. And importantly, some of the Indian courts in the last 2 years have shown deference to party autonomy, and often choosing not to interfere when parties have opted for institutional paths, unless truly there are exceptional cases, as somebody was mentioning in the beginning, where we have agreements where the banks have loan agreements where the names of the arbitrators are involved or the institutions are involved, and they've appointed arbitrators, or orders have been passed, orders have been passed to seize the properties, seize the flats, seize the goods. uh, and these arbitrators basically are the ones who are acting at the instance of the bank, where they've represented as arbitrators for more than 200 cases for that one particular bank, and it's the bank staff who's basically typing the awards and the arbitrators are signing it. So these are obviously exceptional circumstances which do not generalize the Indian arbitration regime.
Mechanical awards.
Yeah, those are mechanical awards, and they don't generalize what the Indian arbitration regime really is in that sense doing. So what we are seeing is not a conflict, but a more complementary approach, which is genuinely happening in the Indian arbitration circle, and courts and institutions are working together to maintain that integrity of the arbitral process, and to ensure that the interim reliefs remain timely, remain effective, and remain enforceable. Obviously, it's a long way, but we are picking up speed, so it's a good sign for us.
Yes, hoping for the best that we are able to define these little things and we are able to move ahead positively,
Absolutely.
especially in regard to the emergent part. So, before we move on to the next main question with Ms. Pariyar, I would like to ask a follow up question. In your opening remarks, you mentioned something about the ad hoc arbitration. Could you please enlighten the viewers what that ad hoc emergent arbitration is? Is it a new concept in India?
So,
Uh,
I know, in fact, I wanted to. Sorry, is that
Sorry.
question for me, Mahir? I'm
Yes,
sorry.
yes, yes.
Right. In fact, that ties very well with what Mr. Jain has just presently said, because he was talking about a remedy which is emergency arbitration, which is an exclusive remedy because of arbitral institution rules that you opt in for. So it's an institutional driven remedy. Now, there are two types of arbitration, like how I was trying to mention and divide that in the beginning in my opening remarks. One is ad hoc arbitration, and the other one is institutional arbitration. Ad hoc arbitration is basically when parties come together, they agree to arbitrate, but they don't say that this particular institution is going to be the one which administers my arbitration. And we will take calls as to when any administration of arbitration which has to be done on our own, and we'll conduct it by ourselves. Now, an ad hoc arbitral tribunal will be constituted either by agreement between the parties, and if the agreement is not getting achieved, then you can file for a Section 9, and a three-member tribunal or a sole arbitrator gets appointed in this format. But parties, at least in terms of party autonomy, the maximum amount of autonomy, at least in my personal view, is given when there is an ad hoc arbitration. This is something which is, like I said, very peculiar to Indian jurisdiction, because outside of India, everyone chooses arbitral institution for adjudication of arbitration in their respective countries. And because it's also very convenient, right? You have an
Yes.
institution which is doing everything for you in terms of the administration of arbitration.
You
It,
repose more faith in the institution.
absolutely. And in fact, there is a transparent process which is taking place, right? There are orders which are coming in a timely fashion. There is a venue which is getting allocated, timelines, any other administrative assistance which you require, you get from the institution. And in addition to that, you have rules which have been framed of the arbitral institution, which guide the entire arbitral process. In an ad hoc setup, parties have to discuss amongst themselves in terms of exactly what arbitral rules will guide their entire proceeding. Whereas in an institutional format, you have arbitral rules which go ahead and guide the entire process. So that way, at least in terms of certainty and exactly what you're opting for when you're going ahead and entering into an arbitration agreement, there is more certainty 100% when there is arbitral institutional rules in place. And in fact, just building upon what Mr. Jain had said with respect to arbitration, emergency arbitration in place, it's again an arbitral institution driven remedy. So if you choose for any of the rules which has a provision of emergency arbitration, it is only then that you can go ahead and avail this benefit or remedy of emergency arbitration. Otherwise, if it's an ad hoc setup, the only remedy of interim nature that you have is Section 17, which you can file before the arbitral tribunal, and not an emergency arbitration. And like Mr. Jain was saying, sometimes emergency arbitrations are the quickest thing that you can actually go ahead and get a relief of interim nature
Correct.
before the arbitral tribunal. So that way, it's very advantageous that at the time of entering into contract, you're sure what is exactly that you're signing up for. If it's an institutional arbitration, then you have these kind of additional remedies in place, which are extremely beneficial, especially in my personal opinion, and I'm sure everyone has gone through the same practice. So that's why it's very important what you are signing up for at the time of entering into contract also.
Of course, even especially vis-a-vis the tender matters, if not the emergency arbitrations, you see some sort of a dispute resolution mechanism, which often seasoned arbitration lawyers call as an eyewash,
Yeah.
because it's one-sided. So that is also there, which must be considered.
And,
That is one side of it.
What Mr. Jain had most importantly pointed out, which I thought was the most relevant point, is that when it's emergency arbitration, at max, I think in 2 weeks, if not 1 week, the standard time to get an emergency award is 7 to 14 days. And no, nothing goes beyond that. So it's such a quick remedy that even if you file a Section 17, what usually happens is that there is a reply or objection which is getting filed. Now that
Yes.
process itself and completion of pleadings for Section 17 itself takes so long. Whereas when there is an emergency arbitration, you know that the award will come in 2 weeks' time or maximum 3 weeks' time if there is an extension which is granted. So in terms of timelines, also it becomes very important for us to examine that at the time of entering into an arbitration agreement, and the amount that you pay for the arbitral institution, because that's an added factor, is again a certainty of amount and expenditure of cost that you get, because you know that this is the amount you are paying and these are the facilities you're getting, as opposed to in an ad hoc setup that everything can change on every hearing basis.
Yes. Well, thank you for that answer. We have a follow-up question for you, if you recall. So this is where is the fine line between Section 9 for preserving rights versus using it to exert pressure on the opposite party? Because as lawyers, we do advise that. Let's be candid about it. Have the courts flagged this?
So, in fact, Sarthak had also touched upon this facet when he was talking about forum shopping. So, another facet of forum shopping or any of these guerrilla tactics, as we call them, wherever it's not prescribed and you're doing something more aggressively than required, at least it's not in terms of the good faith actions which are hoped that a party will take, are these tactics of exerting pressure. Of course, all of us as practicing advocates have sometime or the other gone ahead and file a Section 9 to exert pressure on the other side, because that's a tactical advantage that we can get in a matter, right, for our own client. And there's not, and it's legally available to us, so there is no problem in us to approach Section 9 if it's exerting pressure on any of the sides. Now, in fact, in one of my matters, I will just give some sort of anecdotes to answer these questions and examples from my experience. In one of our matters, we had filed for a Section 9 before the Constitution of Arbitral Tribunal. And the grounds that we had raised were that there is an admitted liability of an amount. So that's what I'm going to claim in the arbitration. That's number one. What is also important to see is that there are financial irregularities in the company, and that's also publicly made available by newspaper clippings, etc. And we could establish that basis newspaper articles that there are financial irregularities. SEBI is looking at it, and third and foremost is that the company was nearly insolvent, and financial instability of the company was also there. So these 3 points together, we could go ahead and get a remedy, get a relief of Section 9 from the court before the Constitutional Tribunal. Now, as soon as we got this order, which in fact was a deposit of the entire admitted amount, the other side comes and tries to settle with us. Because, of course, for them, if they go ahead and give a deposit of that amount, their entire financial capital, whatever they have for running of the company, gets held up, right? So, in order to avoid that, they came to the table and settled with us by having some sort of an installment sort of a method. And they said that, okay, this amount we'll go ahead and give it to you in installments. And accordingly, this as a pressure tactic was successfully exerted by us, and we went ahead and got the order in our favor.
And
So
everybody wins here.
everyone wins. And any event, because there was an admitted liability, the other side would have had to pay either today or later. So for deploying of a Section 9, I think this is the most whenever there is an admitted liability, don't think twice. Just go to a Section 9 court before constitution of a tribunal, follow 38(5) principles or 39(1)(2) principles under CPC, and file for a Section 9 and seek a deposit of the admitted amount. If there is some sort of financial instability which you can make out from any ancillary document, I think that it should be a no-brainer for anyone to go ahead and approach Section 9 court. And another instance which we've had is that it was a matter in which the arbitration agreement was violated. So a suit was filed, and even though there was an arbitration agreement was in place. So as an anti-suit injunction, because there is an arbitration agreement in place, Section 9 was filed, and successfully an anti-suit injunction was, or anti-enforcement injunction was granted. So, I mean, these are very peculiar scenarios where you can go ahead and effectively use Section 9 and seek your relief, whichever your client is requiring at a particular time.
Yes, thank you for that detailed answer. And dear viewers, please note anti-suit injunctions is a vast topic in itself. If you have not visited, we would request you to visit this in-depth topic before entering into this part of the discussion. So, ladies and gentlemen, now let's move on to our next panelist, Mr. Magan. I have a twofold question for you, sir.
Yes.
So, it is, how do you counsel the clients on the strategic use of Section 9 versus relying on the emergency arbitration or Section 17 relief? That is the first part of it. The second part I will ask once you answer this.
Okay. So, insofar as counseling clients on Section 9 versus 17 is concerned, it largely depends upon the pressures. Like Jayashree also said, what can I get? Is there first of all an admitted liability, or is it something that is subject to the arbitration trial? What stage of the arbitration proceedings I'm at for it to be a Section 9? how successful it is going to be under the circumstances. And most importantly, in a pre-arbitral or a post-arbitral scenario, to protect your interests in terms of the admitted liability or the final award, um, um, you absolutely must go to a Section 9 court, either for the invocation of a bank guarantee or for ensuring that the assets remain as they are, depending upon whatever jurisdiction the other party is in. So, like I said, it will be the stage, the nature, and the enforceability of the relief in itself. Um, it will also uh, be to some extent be guided by the jurisdictional complexity of it, of where the arbitration award is likely to be enforced or is being granted, and whether there are institutional rules or choice of law considerations within that. And finally, whether or not, and most importantly, whether you're getting a strategic leverage out of filing a Section 9. A Section 9 being filed in absolute abeyance is a waste of both cost and time considerations. Uh, uh, so I think that will be the larger part of what I will consider while counseling my client.
Thank you for that answer. And just to add on with regard to the for second part of the question,
Yes.
Mr. Magan, we have often seen in tender matters,
Yes.
lawyers are very predominantly approaching the writ courts, and with especially the Tata judgment, etc. The judicial scope has been diluted. So we would want you to touch upon this part, that normally as a lawyer, maybe as a moderator, my opinion here doesn't matter, but as a lawyer, I would say that maybe one could advise their clients to go for Section 9, because often these standardized contracts and big tender documents have one arbitration clause which can come to the rescue. We want you to touch upon that part, please.
But the writ courts are so much wider, Mahir. How do you take the tender matters out of the writ courts and into the Section 9 domain? I don't, in terms of a choice of jurisdiction, especially in tender matters, I would pick a writ court over
a writ court over the
over a Section 9 court. Yes. There are, of course, considerations.
In fact, the entire debate of public law versus private law also gets somewhere intertwinkled when we go ahead and talk about writs versus a contractual remedy, which is arbitration. So I think, yeah, there is no avoiding that.
And
but only with reference to the fact that the judicial interpretations say that we will not grant you stay on the tenders blanket way unless it's spot on, I would say. And but with the Section 9, maybe if somebody is getting blacklisted, the only question is, can we have one remedy under Section 9 to even can it be invoked in such, because against the state also there's an arbitration clause, of course you can invoke, but what is your opinion on this? We would like to know.
Like I said, I would prefer the writ courts because of the wider net of the jurisdiction that they provide, and it's also got to do a lot with the speed, enforceability, and the burdens that I have to carry in a writ court vis-a-vis a Section 9 court. While it would be the same judges of the court, it would be sometimes more often than not the same benches that would be deciding both. But the interpretation becomes very different. Here, in a Section 9 court, a court is interfering beyond its mandate. In a writ court, the court casts a wider net for its own powers, which is why I think tender matters are more popular on the writ side than they are on the Section 9 side. It's not got much to do with the enforceability of the arbitration clauses within it, as much as it's got to do with the large number of and the innovative ways of pressure tactics that you can create on the other side in a writ court.
Or to be loosely wording it, forum shopping maybe.
It could be just as well forum shopping if I was to take up both of those remedies.
Yes. So, Mr. Jain, what's your take on this? Mr. Jain, you're on mute.
Sorry. So I have a little different take on this. While I agree that the writ court does confer a wider net, and you use a lot of office of the writ court in that sense to get what you want. But eventually that distinction will come, and there are certain courts which do draw that distinction, where they say that where there is arbitration involved, you can't come to the writ court. More so because there are going to be disputed questions of facts, and the writ court should not be entertaining cases where there are disputed questions of facts, and they would relegate them for arbitration. Whether this practically is the opinion of that particular presiding judge or not in that particular court is a different matter. But what should be the approach is what I this should be the approach according to me. uh, as a practitioner, uh, I would know what kind of approach the bench is having, and I would use that accordingly. As you guys mentioned, if I know that the particular bench is something which they would be inclined to hear the rate rather than get into the technicalities of whether there is an arbitration clause or not, I would rather move the rate. And if not, then I would go into the section 9 and look for the bench which is going to be hearing the section 9. So depending on the bench, I would pick one. But we are going to reach a stage where it's going to be just the arbitration courts which are going to be involved and not the writ courts which are going to be involved. It's just a matter of time before the Supreme Court comes down with that particular judgment and lays that out very definitely that this is how it should be.
Yes. Yes. In fact, often it is said and quoted that writ courts are not amenable to the contractual disputes. It's the same writ court which sometimes say, with due respect, that we have some unbridled powers. So,
True. And that's why I said, you if you know as a practitioner what your bench is going to be doing, then you would want to do that. But I'm sure that there is going to be time when the bench was going to decide that this is not something which we are going to do it, and please go to the arbitration forum, and we will not be entertaining this in the writ court unless there is actually a state government issue involved, or a state government body involved which has gone beyond what its contractual obligations were, and has uh, violated something which is beyond a mere breach of contract. So it's,
yes.
it's you have to you there will be a test which is going to be laid down. I'm hoping for that.
There
Yes.
should be, and I agree with that. What ought to be is what Isha said, but up until then, there is always the red ones.
Absolutely right, Partner. Absolutely right.
Like what Mr. Matthew McConaughey said, the words are momentary, intent is momentous. Let's see what the intent of the court is, and let's see how it goes. So let's move on to the next question, ladies and gentlemen. My next question is now for Mr. Jain. Sir, this is a very important question. We would like you to answer with all the humility you have. When you wear your arbitrator's hat, how do you view Section 9 orders issued by the courts? Do they support or stifle the autonomy of the arbitral proceedings?
So I'll break that answer into two parts, allowing me to offer that perspective from the other side. So when one wears an arbitrator's hat, it's from that vantage point, Section 9 is like a double-edged sword. It can be enormously beneficial because as an arbitrator, when I view the subject matter, it tells me that the subject matter is preserved. It prevents it from the asset being dissipated. It ensures that the arbitral process is not rendered meaningless before it even begins. And especially when we talk about cross-border disputes also, when the enforcement is complex, the court's Section 9 can be a very very useful tool, and it ensures that the utility and enforceability of the final award is possible. So having said that, there is a critical caveat to that. Excessive or parallel court interventions can quickly turn from a supportive relief into a disruptive force. As a party, you may enjoy the disruptive force because it helps you with the negotiation. As an arbitrator, when I look at it, it's a disruptive force which is hindering the arbitration process. If a Section 9 is used in conjunction with an arbitration process which is ongoing, or in a way to bypass the arbitrator, it can undermine the entire arbitrator's autonomy. it can delay the proceedings, it can compromise the tribunal's authority over the outcome of the dispute, and it raises a specter of forum shopping, in that sense, where parties alternate between, oh, the tribunal has already expressed his opinion during a particular stage of the proceedings, so I would rather explore my opportunities in the court, and depending on the convenience, they would, rather than a legal necessity, you're reaching a stage where parties are choosing their convenience over the necessity, and the real challenge is going to be to strike that balance of how Section 9 must operate as a complementary safeguard, and not as a competing jurisdiction. So this is one angle to it. In terms of, before we began this, Sarthak was mentioning, and I think you were also mentioning, how do you look at the award? How do you look at passing of the final award when there already exists a Section 9 order which is passed by the court?
Yes.
In terms of answering that particular part of the question, uh, well, it's a very, very different way to look at it. When you are looking at passing of the final award, you seldom look at the interim order which is passed in Section 9, as an arbitrator, because by then you have so many things to look at and so many issues to consider that that order under Section 9 is really not relevant to you, because the order under Section 9 is going to cover the prima facie argument. No matter how detailed it is, it's always going to be the prima facie argument, it's going to be the prima facie documents, it's going to be the though when you're arguing Section 9, it doesn't look like a prima facie, it looks like as if you've argued at length and what can be in the arbitration proceedings which are beyond this argument. But factually, when you're a trial lawyer, you would know that no matter how detailed your interim applications are, and no matter how detailed those orders are, when the trial begins, there is a different ballgame which is there. And in an arbitration, when the trial begins and when the cross examination begins and the conduct of the witnesses are taken note of, when the cross examination is concluded, documents are seen whether they can be exhibited, read in evidence, not read in evidence. There are certain documents which get considered at Section 9 stage but may get thrown out in the trial process. There are certain admissions, there are certain cases which are made out in Section 9 arguments, but when the witness is confronted with it, he says, I had no knowledge of this. So
Yes.
a lot of things play out differently once a trial begins, and the arbitrator, when passing the final award, has so many other things to consider that the order passed under Section 9 is really not even in the picture. When we sit with the notes to dictate the award, with the stenographer, you have all the papers in front of you. You really don't look at the Section 9 orders. It's not even on the table. It's in the file, along with the other miscellaneous papers. What you have when you're passing the award is the pleadings of the parties, which is the statement of claim, the statement of defense. It is the affidavit of evidence. It's the cross examination. It's the documents which are exhibited. These are the limited things that you sit with. Rest all interim applications, rest all other miscellaneous applications, other minutes of the orders are all kept aside. These are not which play a role, or at least should play a role when you are passing a final award.
Yes.
No.
In fact, Mahir, I'm just going to assume your role as moderator for a second because I wanted to ask one question from Mr. Jain because it's a very important point that he touched upon
Please,
right.
please do. Please do.
So, more often than not, like Sir said, there are instances where there is a very detailed Section 9 order. And of course, whoever is benefiting out of that Section 9 order, we use that order to go ahead and build our case before the arbitrator. So, from an arbitrator point of view, if it's a lengthy order, it should not, in an ideal scenario, like you said, should sway the opinion of arbitrator. Because
Yes.
in Section 9 order, more often than not, it's clearly stated that it's only a prima facie view and it's nothing more than a prima facie view. But so many times it so happens, like Sir mentioned, that there is a detailed analysis of all documents probably which are going to form part of your arbitral record before the arbitrator. Now, in such scenario, from a practitioner perspective and not an arbitrator perspective, would you rather appeal in Section 37 to get any sort of those remarks expunged, Or would you rather just leave it to the arbitrator to go ahead and not get influenced by any such finding of the Section 9 court?
The arbitrator anyway is not going to be influenced by any such order which is passed. If he's a genuine arbitrator,
Hmm.
he's not going to be influenced by anything that is there, because it does not bind. You don't require a court's ruling in 37 to say that, oh, it does not bind the arbitrator, because no matter what is passed in section 9, nothing which is passed in section 9 can bind the final arbitrator's award.
Absolutely.
So you don't require any observations in section 37.
And just
It's like
as
almost like saying that there is a judge who considers your IA in 2021, and then you finish the trial and you come in 2025 and you say, oh, no, but that IA's order binds you.
yeah.
It's not.
In fact, just a very short, quick follow up.
Yes.
In such a scenario where, of course, the arbitrator is taking call to go ahead and examine themselves, uh, would any such impression also not would you as a party want the arbitrator to look at this order? And of course, if there are two plausible views, arbitrators picking up the one which the Section 9 order has, and that's an option, of course, which is available on basis of which I can't challenge the award. Would you not want your arbitrator to probably have no impression whatsoever of something that has transpired in Section 9? Or is that a utopian concept that I'm probably
No,
craving?
it's not utopian. It's not utopian. It's an effort which is always being made by a lot of parties, like the arbitrations that I have in DIAC also, in
Hmm.
Bombay also. Uh, it's a typically Indian concept, uh, because in DIAC as well as in Bombay, I've had lawyers argue in front of me where they've harped upon that this is what the Section 9 order said. And obviously I can't tell them that you can't argue this because it's the court's order, but it's never swayed with me, and I have never relied upon it, because I have much better facts to rely upon. Is the very content which is in front of me, the record which is formed in front of me.
Correct.
I have a reason to distinguish as to why I do not agree with the Section 9 order if tomorrow it is even taken into consideration, because the Section 9 court did not have the benefit of the record which I have in front of me when I pass the final award. The Section 9 court will always have one, or in fact both hands tied behind, because at the end of the day, the Section 9 order is passed on he says versus she says. It's
Correct.
not going to be based on the cross examination on what he said and what she said. So you've not tested it. It's
Absolutely.
I've I liked what this person has presented, or probably his presentation was better, or his lawyer was better, or whatever it may be. You've understood that person's perspective better, or the lawyer arguing that person's perspective has explained it to you better, therefore you were convinced with that argument. But when you are looking at a trial record, that's not the opinion that the judges form, and that's not the opinion that the arbitrators form. uh, I can't speak for many of the other arbitrators, because as a practitioner I have faced arbitrators who have gone to those section 9s and relied upon section 9s. uh, but that's, as I said, it's a typically old minded Indian concept to rely upon a section 9 order to decide of how you want to run your arbitrations. Anybody who's matured enough to run the arbitration proceedings more practically uh, would look at the record and then do it. And I'm not saying that you would obviously deviate from that. There are many times that you would
Con-
continue in the same lines as a section 9, but it's not because of the section 9 order. It's
That's
because the record is that way.
Yes, yes.
You're not I'm not saying that you would discard it. I'm saying that it's not into consideration.
hmm.
And you may probably come to the same conclusion, but it's not because of the order. It's because of the record that is available with you of the trial.
One very tiny follow up to that.
Yes,
No,
please.
we'll
While
now move
writing,
on to the next one, but I'll just go on to the mantra first. The mantra Mr. Jain is just saying is less impressed and more involved, because we have one last question for the benefit of our viewers due to paucity of time. This question is to Madam Jayashree Parihar, and this question comes way back from the Mahabharat times. That
Hmm.
is with regard to the property because of which Mahabharat started. And this question is, can you share some insights into how Section 9 has been used tactically in real estate or infrastructure disputes where physical possession or site control is at stake.
Right. So, in fact, Section 9, if I go ahead and start clubbing use of Section 9 in infrastructure construction projects, more often than not, a Section 9 is filed. Now, the
Right.
reason behind that is that more often than not, or in fact, in all cases, there would be an underlying bank guarantee. One of the instances would be that there is an underlying bank guarantee in place. Now, to procure a stay against invocation of that bank guarantee, or to go ahead and encash that bank guarantee, you will go ahead and approach a Section 9 court and you will get that remedy. So, at least from bank guarantee perspective, it becomes a very crucial remedy in infrastructure and construction projects. Now, from other perspective, like let's say something that you had hinted at in the beginning, that if there is some videographic evidence that is required and there is a preservation of subject matter at stake, then in that case, like Sarthak said, we can go ahead and get a local commissioner appointed, which is going to go ahead and carry out a detailed examination of the subject matter of dispute, will ensure that the evidence is preserved, will also ascertain who has the possession of the entire project site that is at stake. And in order to ascertain that, we'll at least have a concrete evidence in place, which is going to be the LC report, which is from an independent third party who's conducting such a survey and filing it before the court. Now, in such scenarios, Section 9 becomes a very efficacious remedy for a person in a construction project. And in fact, from a bank guarantee perspective, I'll just circle back to say that there are only exception circumstances in which stay of bank guarantee can be procured. And I would not want to spend too much time on it, but I'll just quickly name it out. If there is a case of a fraud which goes to the root of the arbitration, if there are special equities in place, if there are some condition of the bank guarantee itself which are violated for invocation of it, then you can seek stay of it. Or in certain exceptional circumstances, if there's force majeure, like during COVID times, there were many bank guarantees which were stayed and the invocation of it is stayed. Otherwise, as a general rule, you can go ahead and invoke in like how it is in normal cases.
Thank you. Thank you for that answer. Now, Mr. Magan, please, we would like your remarks on that which we missed, please.
Yes, my only small follow up was, and I know the conversation went the other way after that, but um, uh, a Section 9 order, Mr. Jain, usually resuscitates itself at a 34 stage. That is when it is a tenterhooks with the arbitral award. It's not an issue when it is not, and the arbitral award follows the Section 9. But do you, as an arbitrator, while writing the award, consider it your burden or even one of your burdens to justify why you have gone away from the Section 9 award or not? This is from a completely Indian temperament, understanding that the parties will go to court saying that, well, this is against the Section 9 order and this is why the Section 9 order is the right thing to do at a 34 stage.
No, I would not. For me, that would never be under consideration that I would require to defend my order uh, because I deviated from Section 9. I don't know if you've seen any of my awards, but uh, the way I begin my award is far more detailed, where I begin with describing the parties, describing the issue in brief, looking at the procedural history, looking at the jurisdiction clause, looking at the law applicable, moving on then to what is the case of the claimants, what is the case of the claimants pleaded, then move on to what is the case of the defendant that is pleaded, then move on to what issues have been framed. Then I would show of what kind of evidence has been led by both parties, what documents are marked and are taken into consideration while passing of the award. Then I would move on to each issue, and I would address each issue with dealing with what kind of pleadings are there which is taken into consideration for this particular issue, what evidence in cross examination is taken into consideration while discussing this issue, what law is applicable, what has been argued by both sides for this particular issue, and then give my conclusion. So it's a very detailed analysis, and no matter what you do in Section 9, you could not have that depth of analysis in a Section 9. And therefore, I would really like somebody to try comparing my award with a Section 9 and saying that I missed something in Section 9. So, but it depends of whether the arbitrators put that much of an effort in passing of the award. Uh, I have till date only had one award of mine which has been challenged, and where I'd imposed a cost of 22 lakhs on a party because they were just relentless. And this was way back in 2017. And that time we didn't have the whole culture of cost being imposed on one of the parties. And I imposed a 22 lakhs cost at that time on one of the parties, and he challenged in Bombay High Court. And that award was also upheld by the Bombay High Court. Apart from that, I've never had another award challenged till date. Uh, I don't know the reason behind it, but it's not happened as yet, fortunately. So touch wood.
Okay. Brilliant, brilliant answer. Let's now have very short closing remarks, like 1 minute sharp closing remarks from all three speakers. We'll start with our first speaker, first panelist, Mr. Sarthak Magan. Closing remarks on the issue in 60 seconds.
I think this is something that we couldn't touch upon, and that is a few drafting tips for younger lawyers as to what burdens you should consider while drafting your Section 9 applications. Um, um, I think we've covered it substantially in terms of having a prima facie case, balance of convenience, irreparable injury, the general concepts. In addition to that, the closer you could keep it to a 38.5 or a 32.1, 39.1 and 2, for the court to understand in terms of guiding principles, the more chances of you to secure a better order. Try to have very limited, not vague reliefs, if you could. Um, um, uh, Tailor make your prayers sometimes to judicial comfort, depending upon what the bench sitting before you is. Cite some relevant case law in case this happens a lot in Delhi High Court where benches are transferred, and more often than not, a bench which is deciding a Section 9 application used to be a service lawyer or a criminal lawyer at some point. So it really helps. We've seen in getting the award that you want, and ensure that your urgency grounds are well made. So I think I wanted to cover that. So we.
Thank you. Spoken like a true seasoned lawyer. Let's move on to Madam Jayashree Parihar.
Thanks, Mahir. From my perspective, I think the only closing remarks which I would want to make is that don't get so fixated on choosing Section 9 as an interim remedy, because you have alternative remedies which are more efficacious in certain circumstances, like the Section 17 or an emergency arbitration remedy which is available to you. So just because the remedy is available in court, and there is a certain faith which is there in the legal system towards court, it may not be the best remedy for you to get an interim measure in place. So just be open minded and examine all of these remedies which are available to you under law equally, and not get fixated towards one over the other.
Thank you. Thank you for those remarks. Let's have the closing remarks of Mr. Ish Jain, please.
Thank you, Mayer, and it was a pleasure being here. I don't know the kind of crowd that is listening to us, but assuming that they're all upcoming lawyers and budding practitioners, one piece of advice: that arbitration looks very fancy and looks like a different area of practice. And this is from experience, because I also I'm a senior partner at a law firm, and we have a lot of people who apply for jobs and internships and everything. Just one piece of advice for all those people: that arbitration is not an individual practice area like you have in IPR or electricity laws or aviations or technology law or any of those laws. It's not a specialty on its own. Arbitration is a very very part of the litigation world that is there. And to come and say that, sir, I want to look at arbitrations, or I only look at arbitration practice, is a folly. It's a mistake that you're making in your career. Please do not look at arbitration as its own independent area of practice. It's a part of litigation. Until you do not understand the nuances and you've spent time in litigation, it's going to be very difficult for you to comprehend of what arbitration brings to the table. If you assume that from day one, as an intern and as a fresh lawyer, you are going to be able to practice as an arbitrator, it's you are going to be stumbling multiple roadblocks, and your client's interests are at risk. So it looks fantastic from where we stand today, but we've all gone through the process of litigation to arrive where we stand today. There is no shortcut method in this, is what my recommendation would be to our dear listeners and upcoming lawyers. And best of luck, and always believe in yourself.
Thank you. Thank you for those remarks, Mr. Jain. That was a very great piece of advice for the young and dynamic lawyers. And as far as standing where we stand today, we don't know. But as far as you, I can say you stand tall, bold, and you speak like a true seasoned lawyer, my friend. And on that note, I would like to, on behalf of the Bar Council of Punjab and Haryana, express my deepest thanks and gratitude to our panelists for sparing their valuable time, clarity of thought, and the legal insights that they have offered here today. Of course, it's priceless, especially to a young lawyer who might be having a dispute ongoing maybe in couple of days, and this session will empower them. Maybe he's going to win a petition, maybe they are going to know more nuances, whether they can skip section 9 and maybe they'll file a section 17 itself, and thank in their heads our esteemed panelists later. And that is what the object of this session is. To all the attendees, thank you for being a part of this session, which is an initiative of Vidhi Talks, which is a tried and trusted platform of the humble initiative of the Bar Council of Punjab and Haryana for the e-learning of the young and the dynamic members of the legal fraternity. Until next time, stay sharp, stay curious, and continue pushing the boundaries of your legal discourse, my friends. Thank you and Jai Hind.
Thank you. Thank you so much
Thank
for
you,
having
Mahir.
us.
Thank you.
Thank you.
Pleasure
Thank you.
being here.
Thank you.